Yep, that's it started.
Thank you. Good morning, ladies and gentlemen. Thank you for coming along to this meeting of Clackmannanshire Licensing Board. Are there any declarations of interest? Sorry, first of all, are there any apologies? No apologies. Are there any declarations of interest?
Sorry, Councillor Errol, we have apologies from Councillor Lindsay.
Okay, Councillor Lindsay. Are there any declarations of interest? I see no indication. Thank you. We'll move on to the first item of business, which is the minute of the meeting held on the 23rd of April, page 3 in your papers. That's page 3, page 4, page 5, and page 6. Is that a true and accurate record of the meeting? Okay. I see no dissenters. Thank you. That's moved. We'll now move on to item 4, which is an application for a premises licence review in the name of Clackmannan Bowling Club, number CC 139. Dale, would you like to lead on this one? You're muted.
Oh, apologies, Councillor, just give me a sec. I'm just trying to get the agenda up. Yeah, would you like to hear from Paul first?
Paul, would you like to address the board first? I like a bit of variety.
Yes, good morning, convener, ladies and gentlemen of the board, and welcome to the members of the public that have joined the meeting to hear the procedures of the licensing board today. This matter is at this stage pretty much a procedural matter. The licensing board has received a request for a premises licence review application from a member of the public that relates to Clackmannan Bowling Club. The application is attached to the papers and appears on the face of it to both be competent and reveal some grounds for review. In the background, there is an ongoing complaint, I suppose, that's been ongoing for quite a considerable length of time, and the board should be aware that held by other council officers there's probably quite a significant amount of relevant information. So at this stage, I suppose what's being asked is that are the board satisfied that A, it's a competent review application, B, that they should or should not hold a hearing. The board, of course, have the option of rejecting the review application should they consider it to be vexatious or frivolous, as the language used in the Act. My view as the licensing standards officer on that is that it doesn't meet the threshold for either of those two terms, but that's a matter for the board to consider on reading the actual application. There are certain things that must happen if the board decide to hold a hearing. You must set the date for that review hearing. You must instruct the licensing standards officer to produce a report on the review application and provide the licensing standards officer with a timeline for the provision of that report, which can be any time prior to the date of the hearing. I think realistically, because this report would be required to be shared with the representatives of Clackmannan Bowling Club, the date should be at least 14 days prior to the date set for any hearing. Perhaps 10 days would be an acceptable timeline, but 14 seems to be quite normal. The board are also entitled to make such inquiries as they see fit from any other place. I would suggest that environmental health hold a great deal of what may be relevant information, perhaps more than the licensing standards officer. and a request should be made of the environmental health team leader to provide whatever information that the board think would be necessary. My suggestion would be that the licensing board asks for full details of all of the information that environmental health hold in relation to this premises, to the complaints about this premises in any case, and their inquiries, and that should take the form of a detailed report and include copies of any investigatory material and logs and decision logs about matters that have been addressed. The licensing board may also wish to seek information from Police Scotland to ascertain if there have been complaints of any nature made about Clackmannan Bowling Club to Police Scotland in the period of the complaint. And of course, it's very much for the licensing board to determine how far back in time they seek to request this information, and of course Police Scotland will, and I feel certain that their own environmental health department will of course fully cooperate going back in time with any information requested. I don't think at this stage there's much I can usefully add, as it is a procedural matter that we're addressing today, about whether a hearing should be set, whether the application should be accepted, and what information should be requested. I'm happy to answer any questions if you have any.
You just answered one of the questions I was going to ask, was about involvement from the police, from Police Scotland as well. I believe in your in the letter that Dale has sent in, there is mention that the police being aware of incidents in the past. So I would expect to have a report from the police as well. Board members, first of all, are we happy to go ahead with a hearing?
Chair,
Yeah.
I don't have any problem with going forward with a hearing. It's just I feel we could have been given a wee bit more background evidence, even if it was an initial, we have X number of, we've got, clearly got one complaint, and clearly one's enough. But in terms of, we've got an assertion from a licensing officer saying that it's not a vexatious sort of complaint, but what's his sort of basis for saying that? And also it would have been helpful even at a base level in terms of evidence to have a note of any other complaints that we'd had, and indeed from Police Scotland if they'd had X number of call-outs, for instance. So from my point of view, it would have been useful to have at least some initial additional evidence from the council's point of view as to moving this forward. But in terms of the actual complaint, we should take these sort of things sort of serious in terms of the club licence, which of course has different sort of terms in terms of how it operates, and allowing to sign guests and things in. I think my only worry is that this sort of house is probably, okay, it's probably the closest property to the premises, but the complaints relate to members or people that have been in that sort of function, but they've left the licence, the control of the licensee, if you like, and that's my only nervousness about some of this. But in terms of the complaint and assertion that a licensing officer's made it would seem appropriate to at least have a review of the licence. But I think I would have, and I suppose I'm asking now if we get any at least verbal evidence that you could give us in terms of any additional complaints or evidence from the police that there's been X number of call-outs, etc., would be helpful.
Paul, would you like to respond?
Yes, I think to aid Councillor Balsillie and to respond, it is important at this stage that the board make a decision solely on the actual review application that has been lodged. Of course, a full rundown of all the information that's available from the various sources will be provided in advance of the hearing. But at this stage, the board are required to make a decision based solely on the content of the application to review, which is that one-page email in Appendix A. And they have to be satisfied without any other information that that review application is a competent review application that's dated and signed, it's from a named individual who has provided contact details, and that it discloses or appears to disclose a ground for review, and it is not in the terms of the application, in terms of what's presented before them today, frivolous or vexatious. At this stage, I understand Councillor Balsilli's interest in what lies behind, but it is solely on that one page of information that the decision to hold the hearing and gather other information must be made. In terms of fairness to everybody, it's quite clear from the information that I've asserted and is contained in Dale's report that there is a background to this. It has been an ongoing matter that I expect has been ongoing for more than a year, if that offers a timeline suggestion to the board about how far back they would want to go to environmental health or the police to start gathering information. I am happy out with the confines of the licensing board and before the request for information to go out to provide a date of when I first became involved. I can look at when I first became involved in this matter. I can assure you it is probably more than a year ago, and this has, as you can see from the terms in the review application from the complainer, from the applicant, sorry, for the review, this is in their mind the last resort, because other attempts at resolving the issues have in her view failed. And again, that'll be a matter later for the board to decide whether or not that is the case. But at this time, there is a lot of other information available. I don't think I could even helpfully put a number on the number of complaints that order, and I'm not sure it would help greatly to identify the number of call-outs to Police Scotland. I suspect, again, I would be making assumptions that perhaps it would be unfair, but I suspect that probably they've not attended a number of complaints, or by the time they've got there, the premises have either been closed or there's nothing happening because of response times for non-emergency matters. So I don't think if there's any specific questions that anybody wants to ask about my involvement, I'll be happy to answer them, but I think I can only stress that it's important that the board today make a decision based on the application made and not on what may well be sitting in the background. It's for the board to investigate that and ask for that information.
Thank you. Dale, a comment was made there about the definition of vexatious or frivolous. Can you help us out here?
Yes. Unfortunately, the 2005 Act does not provide an explanation as to what frivolous or vexatious means. However, from the 2005 guidance, a case is frivolous if it has no reasonable chance of succeeding, and it is vexatious if it would bring hardship on the opposite party to defend against an unnecessary and unsuccessful claim.
Thank you. I see someone else in Martha.
Good, Chair. Just one question I was wanting to ask. If we were to go ahead with this application, would the much more information then become available?
Yeah, that's certainly my understanding. Today we're here to discuss, as Paul said earlier on, it is a procedural matter to see if we wish to go ahead with it. So first of all, we have to determine, is it frivolous or vexatious? And I'm quite happy that it does not meet that criteria.
Yeah, I certainly deem that to be the case, Chair. I just wanted to make certain that if this went forward, then we would get more information. We would be able to then work it much more easily. Thank you.
And I think I'm right in saying that now we've established that it's not frivolous or vexatious, do we agree to go ahead to hold a hearing?
Agreed. Yes.
Yes, Chair. I think if I could just intercede, I think we're asking for some sort of parameters, and I would just suggest that we go back 3 years in terms of records, not necessarily to 2012. I think when the individual club licence was issued, but 3 years ought to give us recent history in terms of events and things like that, and that we ask for full information from our environmental health and indeed the police in terms of call-outs, etc. And indeed any interactions our own licensing staff, particularly Paul, have had with the bowling club. I think those might be reasonable parameters to put in place, but I'm happy if others want to go further back. I would have thought 3 years would be a reasonable threshold to look at, because it's probably, if the applicant has the attest of things have kind of got worse, then that should be picked up in that the most recent 3 years of activity of the bowling club.
But thank you for that, Donald. But I reiterate, we are here to determine where we wish to go ahead with the hearing.
Yeah. Sorry, Chair. I thought we'd already agreed and determined that was the case, that we do. We've determined with what information we've got and the advice from our licensing officer that it's not, the complaint is not vexatious or frivolous, and therefore we need to investigate it and gather evidence. And the parameters of that, I'm suggesting we go back no more than 3 years, but we gather all the information that we have from environmental health within that period, and indeed the police and Paul Fair's own interactions with the club and their conduct.
Thank you. Paul, to return to you, we are required now to set a date for a hearing, am I correct? Dale?
Yes, that would be correct, and I would suggest that the next scheduled licensing board, which I think takes place prior to summer recess, would be a suitable date. What date? I see, Mel. 25th of June, I think, is the date that that's been provided to me over the barrier by Melanie. So I think that's probably allows sufficient time to prepare. What I think actually, I don't think it'd be appropriate to delay it any longer than that. I think certainly, I wouldn't imagine it would be very difficult for Police Scotland to pull together a summary of matters that they deem relevant. They, of course, may choose not to reveal information for as far back as 3 years. You can make that request, but they may choose not to reveal it for that far back. However, obviously, environmental health is a matter for them to decide what they can produce and pull together. I have no difficulty personally producing information as far back as my involvement in the start of this matter, but I'm not quite sure how far back it goes. However.
Okay. We all agree that the meeting should be held on the 24th of June, correct?
25th.
25th, yep.
25th of June, my apologies.
Agreed.
Yep, agreed. 25th of June, the date, Dale?
Agreed.
Okay. I'm quite happy. I'm interested in being fair to all parties to the proceedings, and I want to make sure that the police will be quite happy with the 6 weeks as well. So, but we set the date for 6 weeks, so hopefully the information and that will all come. Deal.
Councillor, do you just set a date for when the reports are due?
Yeah, I think the report should be due in at least 2 weeks before the date of the meeting.
Okay.
Well, 2 weeks. How long's that from? So if that's 25th, that's the 11th. Do we know if that will give Paul enough time and the environmental health and also Police Scotland? Because that's then only, what? That's 2 weeks for them, basically.
I'm quite happy that we've been asked to set a date and to get reports. We are talking about 4 weeks, roughly.
It's
And I
only,
think,
you're technically only given 2 weeks for the reports to get done. So I'm just asking, is that enough time for?
yeah,
These matters are always time sensitive, and they no doubt will put a little bit of pressure on certain individuals to produce reports, but it's that's a matter for them to address in terms of managing their workload. These are important matters. I'm on holiday for a week in that period as well, but I'll ensure that my side of things are done in plenty of time to make sure that it arrives for the agenda deadline for the board hearing. I don't know what the volume of information is elsewhere, so it's difficult for me to comment at this stage. But that's, I mean, all the board can do is ask for the information, set a date by which that information should be received, and if the information isn't received by that date, then that's a matter for the board to take up. I don't think it's unreasonable. As an aside, I have advance information from Police Scotland that next licensing board date will be suitable for them. Sergeant O'May, who you're all familiar with, retires or has perhaps retired. I think yesterday was his last day, and he passes on his gratitude for the work that he's done with the licensing board in Clackmannanshire. He's been replaced, I think, of today, but Police Scotland were attending another licensing board today, so unable to attend here today to contribute in terms of that matter. But they have advised me that the next licensing board meeting would be no difficulty for them to produce what's required of them or what's requested of them in relation to the premises.
okay.
I think they normally then would submit their report 2 weeks before the licensing board's due, so they're happy with it. Right, that's grand.
Yes, that would be normal council law, that they would have their stuff to us by the agenda deadline.
Okay, Rod, does anyone else have any other contribution to make?
Sounds like a plan to me.
I was just going to ask, obviously it's a neighbouring property who's asking for the review. Do the other neighbouring properties get contacted to find out if they've felt the same in regards to the circumstances?
Oh,
yeah, as part of the report that you're going to request or have requested that I complete, which is a statutory requirement in terms of the legislation, that the licensing standards officer must complete a report on the application. Of course, if there's any inquiries that in particular that you would like me to make or attempt to make in that period, then they could be detailed in the instruction to me, which would come via the clerk, I suppose, for any specific inquiries. And if what you're suggesting, Councillor Law, is that some inquiries with neighbours are made, then yes, that's part of what I would do.
Yeah,
I think it's a reasonable idea.
Yeah, I think that'd be helpful way forward.
yeah. Is there any other contributions? Okay, so we've moved the date for the hearing. We've agreed it's not frivolous. I'm not going to say it again. Vexatious, or that other word. With that in mind, I'm going to close the meeting. Is there any other, before I do so, is there any other competent business? No. That's the meeting closed, ladies and gentlemen. Thank you very much for your attendance.
Thank you.
Thank you.